A federal judge just threw the first major legal roadblock at Trump's freshly signed Big Beautiful Bill, and the target reveals everything about Republican priorities. While the bill cuts healthcare for millions of Americans, the court challenge focuses on one specific provision that exposes the true agenda behind this legislation, and it could unravel much more than just Planned Parenthood funding. The judicial pushback came faster than anyone expected. Within days of Trump signing his massive spending bill into law, a federal court issued a 14-day temporary restraining order blocking a critical section that would freeze all Medicaid funding to organizations that primarily perform abortions or provide abortion-related services. While the legislation doesn't explicitly name Planned Parenthood, everyone understands the target. This one-year funding freeze would affect more than 1 million Medicaid recipients who rely on these organizations for essential healthcare services, not just reproductive care, but cancer screenings, STD treatment, and basic medical services that keep communities healthy. The legal challenge argues this represents a backdoor approach to ban abortions while violating equal protection under the law. But the implications go far beyond this single court case. The constitutional argument at the heart of this case exposes a fundamental contradiction that could reshape how we understand federal versus state power. Throughout the Roe v. Wade reversal campaign, Republican politicians repeatedly promised that abortion decisions would return to the states, that local communities and state governments would have the authority to make these choices for themselves. Yet here we have federal legislation that directly contradicts that principle. States that want to allocate their Medicaid funding to Planned Parenthood are being told by the federal government that they cannot make that choice. This represents exactly the kind of federal overreach that Republicans have historically opposed when it served their political interests. The hypocrisy runs deeper than just states' rights rhetoric. This legislation specifically targets organizations providing legal medical services, essentially using federal spending power to discriminate against disfavored healthcare providers. As the legal challenge argues, our government cannot pass laws that specifically target businesses providing lawful services simply because those services are politically controversial. But this case raises questions that extend far beyond Planned Parenthood funding. The temporary restraining order comes at a time when the Supreme Court has been limiting federal judges' ability to issue nationwide injunctions, particularly those that constrain executive branch power. However, the situation differs significantly from recent precedents. Rather than challenging executive action, this case examines a newly passed federal statute for potential constitutional violations. The court is exercising traditional judicial review, examining whether legislation violates constitutional rights and protections. The distinction matters because it suggests federal courts retain significant power to check federal overreach, even in the current judicial environment. If this temporary restraining order survives legal challenges and becomes a preliminary injunction, it could establish precedent for courts to examine other sections of the Big Beautiful Bill for constitutional problems. This creates a fascinating legal dynamic. While the Supreme Court has limited federal judges' ability to restrain executive action, it has preserved their traditional role in reviewing legislation for constitutional compliance. That preservation could prove crucial as various aspects of Trump's agenda face judicial scrutiny.
The real test will come in the next 2 weeks, as this temporary restraining order faces inevitable challenges. But the underlying legal arguments reveal something important about Republican governance strategy. They're willing to abandon their own stated principles about federalism and states' rights whenever those principles conflict with their policy agenda. More concerning is the pattern this suggests for how the Trump administration will respond to adverse court rulings. Historical precedent shows a willingness to simply ignore judicial decisions when they prove inconvenient, as demonstrated during the Ukraine aid controversy, where congressionally appropriated funds were improperly withheld for political leverage. The question isn't just whether courts can stop unconstitutional provisions in this legislation. It's whether the executive branch will respect judicial authority when that authority constrains their agenda. We may be about to witness a fundamental test of whether our system of checks and balances can function when one branch simply refuses to acknowledge the legitimacy of the others. For the more than 1 million Americans who depend on Medicaid funding for essential healthcare services through Planned Parenthood, this legal battle represents more than constitutional theory. It's about access to cancer screenings, STD treatment, and basic medical care that keeps communities healthy. The broader implications reach every American who believes in constitutional governance and the rule of law. If federal legislation can target specific organizations providing legal services simply because those services are politically disfavored, then no healthcare provider, advocacy organization, or business is safe from similar political persecution. This case will reveal whether our courts can still serve as a meaningful check on legislative overreach, and whether our constitutional system can survive an administration that views judicial oversight as illegitimate interference rather than essential democratic accountability. This legal challenge could be the first of many constitutional battles over Trump's big beautiful bill. What do you think? Can federal courts still effectively check congressional overreach, or will the administration simply ignore adverse rulings? Share your thoughts on whether our system of checks and balances can survive this stress test. Don't forget to subscribe and hit that notification bell to stay informed about the legal battles that will define the next 4 years. Your engagement helps us continue tracking the cases that will determine whether constitutional governance survives.